Sunoco and they're ignoring my commands to stop. Come here, please.
No.
What do you mean, no?
No.
Please do not talk to them right now. I need to deal with them.
Oh, then let's go.
Okay. You're not leaving. I need
You're touching me. You're touching me. That's assault.
It's not assault.
It's assault. It's assault. You're touching me. You put your hands on me.
Whiskey Ford, come over here. They're refusing to stay where I'm at. And
I don't got to. It's called clerk property.
No.
Yep. Stupid.
I can follow you all day.
Don't care. That's your job.
Yep, it
You get paid
is.
by the hour, right?
Just a waste of
That's
tax
right.
dollars.
You want to take you on a long ass walk.
Are we?
Yep.
Y'all threatened to shoot the...
No, it's y'all. We didn't do anything. He didn't do anything.
And there was no apparent reason why they said you were. Watch him for guns.
Come on, man. Take it long. Right here. You'll be all right. Here. Come in. Get the left one, man. I'll take too long. Here. Come on, here. Here. Where my fucking hand come from?
Just stop resisting.
I'm not resisting. I'm trying to help your stupid ass out. You want to
Roll onto your stomach.
All right. Say please.
Roll on your stomach.
If you move, I want to hit you in the neck, dog.
Roll onto your stomach.
You're going to be dog bit. You understand me? Hey, if I call 911, you're going to pop up, right?
Roll onto your stomach.
I see your face.
Okay, I see your face. Roll onto your stomach.
It don't matter. I can pop up anytime. You got to roll. 20 people. How about roll? Stop trying to force me. How about roll?
Roll onto your stomach.
I am. If you get down, stop trying to break my arm, I ain't going to do shit.
If you stop
I'd
resisting.
rather y'all break my shit and motherfuckers.
Why are you on your back?
Because y'all ain't being nice sometimes. Hey, get the fuck off me. No such shit. All right, here. Hey, bro, don't grab my dick. I am. I'm the.
All right. You're
So
going
what's
to
the
roll
problem?
onto your stomach.
What's the problem? What I've been detained for? What I've been arrested for?
You are being detained for an investigation.
What investigation?
Something that happened in the mall. I don't have to
Ain't
explain
nothing
myself
happened
further.
tomorrow. Where I'm at? Am I at the mall?
Nope.
So this is public cover, right?
I'm not going to explain further.
Where your body cam at?
I'm not going to explain
Where your
any
body
further.
cam? Oh, that's it right there.
Dude, turn the fuck over. Just get handcuffed.
Roll on your
Telling me to
stomach.
tell the fuck. Look, I'd rather listen to you than these motherfuckers. You keep trying to
Roll
make my
onto
arm.
your stomach.
I am. For you? You want me to roll over? You don't want me to be nice. Why you tell
I
me that?
asked you
Hell no. Stop
several
saying that.
times. Roll onto your stomach.
You asked me. Okay, here you go. You
Roll
asked.
onto
You
your
said you
stomach.
asked, so I am. Tell him let go my arm. I can't go.
Roll onto your right onto your stomach.
Hey, my hand. Stop trying to break my shit. Go the head. Here, get off for a second. Go to the side. Go to the other side. Here you go. Here you go. Oh, you're not going to get one.
Shot for Alpha 41014.
911, I will be calling. Y'all will pop up. What you doing? I'm swearing to you. Y'all gotta pop up.
No, stay seated.
Why? Can I get on the grass? I mean, off the grass? Maybe I know it now. I'm good. Leave me alone. Go back to business. Go back to business. You jackass. You too.
Do you have a free seat?
So, I do, but my fucking car's
that motherfucker there.
Sunoco.
That
we'll talk
motherfucker
about
there.
it in a minute.
You. Start with you. We gonna have a conversation.
We'll talk about it in a minute.
Hey, you're a civilian?
I'm going to tell you one time. Do not stand up.
Hey, is he a civilian?
Do not stand up.
Is he a civilian?
I don't know who you're talking about.
The white shirt.
I have no idea who he is.
You got him. I'm gonna let him. You good. You good. I ain't about to do shit.
Yeah. All right, what is your question?
What's going on today?
What?
What's going on today?
So, you can readily understand English. Am I correct in this?
Yes,
You
sir.
spoke English your whole life, right?
In Spanish, right? Yes, sir.
Okay.
Both languages.
Do you understand the rights I read to you earlier?
Yes,
Not that you understand the situation, because I haven't
wasn't trying
explained
to be
most of that.
funny because I didn't do anything. I'm really like confused.
Right.
I work
But-
at the mall. I
So-
work at. Go ahead.
Let me explain it to you, but I need that clear to you before I explain it to you, because you're gonna ask questions and I'm gonna ask questions. We're gonna go back and
That's
forth,
fine.
and
Yes, sir.
I need everything to be clear. So, a situation happened at the mall. Pretty much as part of our investigation, we have the right to detain people who are part of that. So, when the officer comes up to you and says, stop, and you walk away, you walk in the Sunoco, you walk out of the Sunoco, you keep walking down the street, that gives us probable cause to arrest you for resisting without violence. When you're given a lawful order to stop, you have to stop. What?
No, I said I didn't know that, but now I know.
Okay, no one's ever told you if a police officer tells you to stop, you have to stop?
If you're not guilty, though.
So you just get to determine that you didn't commit a crime?
No, sir.
So how do you explain this to me? How do we investigate a crime if anybody can just walk away at any particular point? Exactly. So we have to be able to detain someone to do that, right?
Yes, sir.
So we have to be able to physically force them to stop. Now, as I read your rights to you, you don't have to talk to us, but we have to be able to identify you, have witnesses identify you, and conduct an investigation in relative calm, which doesn't really work if you're walking away and not following commands to do so. Okay, so you understand all of it. Okay. So, basically, at any point, did anyone say anything about a gun inside the mall?
Neither one of us, no.
So someone else said something about a gun.
Yeah, but that's what I was like. He literally like this. Okay, I'm not laughing at you. This is like really pathetic. I work in the mall, so this is the second time that dude, the tall dude, the owner. So he had an issue with, like, they don't even know who we are. That's why I was like, that's kind of stupid. So my parents are very.
Why would he have an issue with you?
Because of him. I didn't do anything.
So you're just sitting there and you just
comes like, up to if you look at the video, I promise you, I'm sitting in the nursing room. I'm waiting on my best friend. I have to go to work. I'm not. So he's like pulling on the door. So I text him like, "Yo, I'm changing. You see all these clothes? I'm changing my clothes so I can go to work. I have to ride a bike to go to Hotel Indigo. I work at Hotel Indigo. As matter of fact, you can see my badge. Name badges in there. So I'm like, I'm walking out. They're like, so we left like they instructed. So he likes to play games or whatever. But when they said leave, we left. That's why you see us crashing the street. We go there every day. Like we don't bother anyone.
Were you guys wearing masks when you were wandering around in the mall?
We wear a mask every day, but not in the mall. No.
Okay. So
I wear it when I came outside. She seen me pull it up.
All right. So. No one, you two didn't mention a gun, but someone else did.
Yeah, the dude that works there.
When did he say that?
He said that in the mall. When we were in the mall. So when he was following us, he was like, "Oh, if you don't leave, we'll call the police or I'll shoot you." What? Why would you shoot us if we're walking away? That's why they did all that scene. That's the second. This is the second time this happened.
But that doesn't make any sense. Like, why would they do that to you?
Because
for no reason.
He wants to play it. Like, he doesn't know who I am. He's sort of like, I don't know who that. You know exactly who we are.
Okay, but why you? Like, because does he not like you?
He doesn't.
Like, why would he just single you two out of nothing?
He's not going to tell you this. So when I was with my homegirl, which is one of his people's daughter, he was trying to talk to me. So you felt some type of way because he said something to you about trying to holler at his wife, his fiance. So you're mad because I don't want to talk to you. That's not a place. This is a place of business. I work there. That's what I was like. I help my friend at the kiosk. One, she sews hats. We sit there. He sees me all the time. So I was like, the fact that you blew this out, I left just when you said leave, we left. So,
all right.
Didn't do anything. She told me that when she was out there, put your hands behind your back. Yes, ma'am. Put my hands, stop moving.
You were fine.
That's all I didn't do anything.
Got a bunch of problems from that one. All right. So, how old are you?
I'm 26.
26. All right.
This is the moment most people believe they still have a choice. Legally, that belief is already eroding. The call that brings officers to the mall is not about inconvenience or disagreement. It is about reported threats. That single detail changes the constitutional posture of everyone involved before officers even arrive. Threat allegations elevate a situation from consensual contact into an investigatory obligation. Police are no longer free to ignore it, and civilians are no longer free to treat it as optional engagement. The law now requires officers to identify, separate, and control the subjects connected to the report, even before verifying every detail. Police involvement becomes inevitable because threats implicate public safety, not private conflict. Once dispatch relays that people inside a public mall are allegedly threatening others, officers acquire a duty to act. That duty is rooted in the government's obligation to prevent imminent harm in public spaces. This is not discretionary curiosity. It is a mandated response that authorizes temporary detention, scene control, and command presence. The legal justification does not depend on whether the threat ultimately proves credible. It depends on whether the report itself is reasonable enough to investigate. This is where a common misconception quietly fails. Many people believe police must first prove a crime before exercising authority. Constitutionally, that is incorrect. Officers may detain individuals to determine whether a crime occurred, is occurring, or is about to occur. The law distinguishes sharply between investigation and punishment. At this stage, officers are not imposing consequences. They are preserving the ability to decide later whether consequences are warranted. Initial contact inside a mall introduces another invisible legal shift. A mall is private property open to the public. That status matters. While individuals retain constitutional rights, property management also retains authority to regulate presence and behavior. When police respond in coordination with mall security or management, they are not enforcing private preferences. They are responding to reported criminal conduct occurring on private property open to public access. That hybrid environment expands lawful command authority because officers must simultaneously consider criminal law and trespass law. The first commands issued are not requests. They are investigative controls. When officers instruct individuals to stop, remain where they are, or refrain from interacting with others, those instructions serve a constitutional purpose. They prevent evidence contamination, witness coordination, and escalation. Courts consistently uphold brief, location-based detention during threat investigations because the alternative is uncontrolled movement in a public space. At this moment, compliance is not about guilt. It is about maintaining investigatory order. Speech and conduct diverge sharply here. Individuals retain the right to speak, protest, criticize, or remain silent. They do not retain the right to physically disengage from lawful detention. This distinction is foundational. The Constitution protects expression, not evasion. Walking away from officers during an active threat investigation transforms the encounter legally, even if the person believes they have done nothing wrong. The law does not condition detention authority on a suspect's agreement with its necessity. Another misconception collapses at this point, that officers must immediately explain everything. Procedurally, they do not. During evolving investigations, officers are permitted to issue commands first and explanations later. This is not secrecy, it is sequencing. Explanation requires stability. Stability requires compliance. Courts recognize that requiring full articulation before securing subjects would undermine officer safety and investigative effectiveness. As individuals refuse to remain in place, legal exposure begins to compound. The refusal itself becomes a new fact. Not a moral one, a legal one. Each step away from lawful commands adds an independent basis for detention escalation. Importantly, this escalation does not depend on whether the original threat allegation is ultimately substantiated. Resisting or obstructing an investigation stands on its own once lawful authority exists. Officers' tone remains controlled because neutrality preserves admissibility. Emotional engagement, sarcasm, or visible frustration can later be framed as provocation or bias. Calm repetition of commands establishes a clean record: lawful order issued, order refused, escalation justified. This is not about winning an argument in the moment. It is about building a record that survives judicial scrutiny months later. The involvement of mall personnel introduces corroboration, not validation. When individuals identify themselves as security or management, officers do not accept their claims as truth. They treat them as information sources. Verification happens later. But their presence explains why officers cannot simply disengage. Multiple parties are asserting authority, reporting threats, and requesting intervention. That convergence strengthens reasonable suspicion, even if details remain disputed. At this stage, silence would be legally protective. Silence does not impede detention. Silence limits the creation of additional evidence. Arguments, accusations, and legal threats do not halt police authority. They often do the opposite by extending the encounter. The Constitution allows silence precisely because the law recognizes how quickly statements can escalate exposure during dynamic investigations. The moment physical contact occurs, another misconception fails. Physical contact by officers during lawful detention is not automatically assault. It is evaluated under reasonableness. Courts assess whether force was proportionate to resistance, not whether resistance felt justified to the person resisting. Once commands are refused, officers are permitted to use reasonable force to enforce compliance. The legal analysis begins with the refusal, not the reaction. This answers one legal question clearly: were officers authorized to detain individuals who refused to stop during a threat investigation inside a public mall? Constitutionally, yes. The authority arises from the reported threats, the public setting, and the need to control the scene. But resolving that question exposes a more serious risk forming underneath. Once refusal escalates into physical non-compliance, the legal focus shifts away from the original threat allegation. The investigation begins to center on resistance itself. That shift is subtle, procedural, and often invisible to the person experiencing it. At this stage, the most consequential legal exposure has not yet fully materialized, but the foundation for it is now firmly in place. Leaving now would miss how quickly lawful authority transforms disagreement into detention, and detention into arrest, through decisions that feel minor but compound under the law. This is the moment many people believe resistance is still a matter of debate. Legally, it is not. Once lawful detention has been established, the analysis shifts from why officers are present to how subjects respond to authority. At this stage, the law stops asking whether police involvement was justified and begins asking whether commands were lawful and whether they were followed. That distinction is decisive, even when the underlying incident remains disputed. Escalation occurs not because of tone or attitude, but because of conduct. When officers give clear commands to stop, remain seated, or reposition, those commands carry legal weight once detention is active. The Constitution does not require officers to persuade. It requires that commands be lawful and reasonably related to the investigation. Repeated refusal transforms the encounter procedurally, regardless of how strongly the subject believes the detention is unjustified. A common misconception collapses here, that verbal disagreement preserves autonomy. It does not. The right to argue survives detention. The right to physically disengage does not. Courts draw a bright line between speech and movement. Speech may be protected even when hostile. Movement that undermines detention is not. This is why officers repeatedly separate verbal protests from physical compliance. They are not suppressing speech. They are enforcing control. At this point, the law begins evaluating resistance independent of the original call. Resistance does not require violence. It requires interference, pulling away, refusing to roll, failing to comply with positioning commands, or attempting to stand when told to remain seated all qualify as obstruction once detention is lawful. Importantly, the law does not require officers to pause and renegotiate after each refusal. Continued non-compliance compounds exposure. This is where many defenses that feel intuitive begin to fail. Claiming confusion does not negate refusal when commands are clear and repeated. Claiming disagreement does not suspend authority. Claiming innocence does not restore freedom of movement. The law treats detention as a temporary loss of choice, not a negotiation. Once that loss occurs, compliance becomes the only lawful path forward. Officers' calm repetition serves a legal function. Each repeated command documents opportunity. Courts look for whether a subject was given a chance to comply before force escalated. Calm repetition demonstrates patience and proportionality. It also eliminates later claims that force was sudden or unnecessary. The more opportunities documented, the stronger the legal justification for escalation. Another invisible turning point occurs when force is introduced to gain compliance. Force here is not punitive. It is corrective. The purpose is to restore control, not to punish resistance. Courts evaluate force by asking whether it was reasonably calculated to achieve compliance under the circumstances. They do not require that force be minimal in hindsight. They require that it be reasonable at the time. Threats of additional force, including warnings about canine deployment or physical restraint, are part of this analysis. These warnings are not intimidation. They are noticed. The law favors warning over surprise. Informing a subject of consequences before applying force strengthens the legality of the force if it becomes necessary. Silence would actually weaken the record. This stage also clarifies why officers continue issuing commands even while force is applied. Compliance remains the goal. Force stops when compliance occurs. Courts expect officers to continue offering a path back to voluntary compliance throughout the encounter. That expectation is visible in repeated instructions to reposition, stop moving, or place limbs as directed. The question of custody becomes unavoidable here. Detention has matured into arrest once probable cause exists for resistance. Probable cause does not require certainty. It requires reasonable belief based on observable conduct. Repeated refusal, physical pulling away, and failure to follow commands supply that belief. At that moment, the legal status changes, even if handcuffs are not yet fully applied. This is where constitutional rights quietly shift again. Once arrest is supported, officers gain authority to search incidents to arrest, maintain physical control, and prevent escape. The subject's belief about whether arrest is fair is legally irrelevant. Fairness is adjudicated later. Compliance is required now. Claims of unlawful touching or assault by officers often emerge at this stage. Legally, those claims hinge on whether force exceeded reasonableness. The analysis does not begin with the subject's perception. It begins with the sequence of commands and refusals. If force follows refusal and is proportional to resistance, courts routinely find it lawful. Another misconception fails here, that announcing constitutional rights during resistance preserves them. It does not. Rights exist regardless of whether they are spoken aloud. Invoking them does not pause enforcement. Courts consistently reject arguments that verbal invocation negates the obligation to comply with lawful commands. Rights protect against unlawful action, not lawful arrest. Silence would again be legally powerful here. Silence avoids additional statements that can be interpreted as intent to resist or awareness of commands. Statements made during struggle often become evidence of knowledge and refusal. The law does not require subjects to assist officers verbally. It requires them not to interfere physically. The involvement of additional officers reinforces the procedural shift. Backup is not a sign of excessive response. It is a sign of risk management. Multiple officers reduce the need for higher levels of force by distributing control. Courts view additional officers as a de-escalation measure, not an escalation one. This phase answers one legal question definitively. Once lawful detention is established, does refusal to comply create independent grounds for arrest? Legally, yes. Resistance is its own offense, regardless of the outcome of the original investigation. But answering that question opens a more serious one. Once arrest is justified for resistance, officers are no longer required to resolve the original dispute before imposing consequences. The encounter has crossed a procedural threshold. What began as an investigation into threats now carries its own criminal exposure, separate and self-sustaining. The most significant legal consequence has still not fully emerged, but the pathway to it is now unavoidable. Each additional movement, statement, or refusal will be evaluated through the lens of arrest, not inquiry. Leaving now would miss how quickly resistance replaces the original allegation as the central legal issue, and how that replacement reshapes everything that follows. This is the moment most people believe the damage is already done. Legally, it is not. The most consequential shift occurs when the encounter moves from physical control into post-arrest processing. At this point, the law stops focusing on how compliance was achieved and starts focusing on what evidence has been created. Control has been restored, but legal exposure is still evolving. Once arrest authority exists, every subsequent interaction is evaluated differently. Statements are no longer contextual background. They become potential admissions. Questions are no longer exploratory. They are evidentiary. This is why officers slow down, lower their tone, and formalize communication. The encounter has crossed from dynamic enforcement into constitutional procedure. A critical misconception collapses here, that explaining oneself after arrest can undo what just happened. It cannot. Arrest crystallizes facts already observed. Post-arrest explanations do not erase prior resistance. They may clarify motives, but motives are not elements of the offense. The law focuses on conduct, not justification, when evaluating resisting or obstructing charges. This is where Miranda warnings become relevant. Miranda is not about fairness in the moment. It is about admissibility later. Once officers anticipate custodial questioning, they must advise subjects of their rights. These warnings do not signal that guilt has been determined. They signal that statements now carry heightened legal consequences. From this point forward, the Constitution presumes that any voluntary statement is knowingly made. Another misconception quietly fails, that being read rights protects against consequences. Rights protect against compelled self-incrimination, not against prosecution. A subject may speak or remain silent. Both choices carry legal implications. Silence preserves uncertainty. Speech narrows it. The law allows silence because it recognizes how easily speech can solidify exposure after arrest. Officers' controlled demeanor persists for a reason. Emotional engagement after arrest risks claims of coercion or confusion. Courts scrutinize post-arrest statements closely. Calm explanation, clear phrasing, and confirmation of understanding protect the integrity of any statement obtained. This is not courtesy. It is constitutional hygiene. At this stage, officers often explain the legal basis for arrest. This explanation serves clarity, not persuasion. The law does not require agreement. It requires notice. Explaining that refusal to stop or comply created probable cause establishes the procedural record. Whether the subject accepts that explanation is irrelevant to its legality. A subtle but critical legal turning point occurs when subjects continue arguing their version of events. These narratives may feel exculpatory, but they often introduce inconsistencies. Statements about where someone was, what they did, or why they acted become benchmarks against video, witness accounts, and officer observations. Later, discrepancies are not viewed as misunderstandings. They are viewed as credibility issues. This is why silence is often the strongest legal position after arrest. Silence does not imply guilt. It prevents additional evidence from forming. The law permits silence precisely because post-arrest explanations rarely help and often harm. Once arrest has occurred, the investigative focus has shifted away from whether officers were justified and toward whether charges can be proven. The presence of witnesses and third-party accounts now gains weight. Officers are no longer deciding whether detention was lawful. That decision has already been made. They are documenting corroboration. Statements from mall personnel, security, or bystanders are evaluated alongside bodycam footage and officer observations. The legal question is no longer what happened inside the mall. It is whether the elements of each charge are satisfied. This is where certain defenses begin to erode. Claims that officers lacked authority to detain are undermined by the sequence of commands and refusals. Claims of misunderstanding are weakened by repeated instructions. Claims of innocence regarding the original threat allegation do not negate resistance charges. Courts separate the justification for detention from the offense of resisting it. Another misconception fails here, that disorderly conduct or similar charges are subjective. They are not. They are defined by statute. Disorderly conduct often hinges on behavior that disrupts public order or interferes with lawful activity. In a crowded public mall, refusal to comply during a threat investigation directly implicates those statutes. The setting matters. Public disruption carries different legal weight than private disagreement. Aggravated assault charges emerge only after a careful evidentiary threshold is considered. They are not based on insults or attitudes. They require conduct that creates a reasonable fear of imminent harm or involves physical aggression. Officers do not announce such charges lightly because they must be defensible later. The record must support each element independently. This stage also explains why officers stop debating constitutional theories roadside. Courts are the venue for constitutional arguments. Officers are tasked with enforcing existing law, not litigating it in real time. Continuing to argue constitutional amendments during arrest does not preserve rights. It creates statements that may later be used to show awareness of commands or intent to resist. The legal exposure now extends beyond the original interaction. Arrest triggers booking, charging review, and prosecutorial discretion. Each charge will be evaluated for sufficiency. Some may survive, others may not. But the decision-making process is now insulated from the immediacy of the encounter. That insulation favors procedure over perception. This section resolves one legal question clearly. Once arrest occurs, does continued argument or explanation reduce criminal exposure? Legally, no. It often increases it by generating additional evidence. But resolving that question introduces a more consequential risk. Charges are now being selected. Prosecutors will decide which statutes apply and which facts support them. That decision has not yet been revealed. It will depend on how the recorded conduct aligns with statutory elements. At this stage, exposure is no longer hypothetical. It is being shaped quietly by paperwork, reports, and review processes outside the camera's view. Leaving now would miss how post-arrest procedure, not emotion, determines which consequences ultimately follow, and why some defenses that feel compelling fail once the law begins its final evaluation. This is the moment many viewers believe the outcome is already locked in. Legally, it is only beginning to take shape. What follows arrest is not a continuation of conflict, but a transition into evaluation. The law now shifts from street-level authority to institutional judgment, where decisions are filtered through statutes, reports, and prosecutorial standards rather than voice, posture, or persistence. Once charges are articulated, each one reflects a separate legal theory. Disorderly conduct addresses disruption of public order during a lawful investigation. Resisting arrest focuses on conduct after lawful detention authority has been established. Aggravated assault, when alleged, examines whether actions created a reasonable fear of imminent harm or involved force against an officer. These charges do not blend together. Each must stand independently under statutory elements. A common misconception collapses here, that disproving one charge collapses them all. It does not. If the original threat allegation inside the mall fails to meet evidentiary standards, that does not retroactively invalidate resistance that occurred during the investigation. Courts consistently separate the legality of police orders from the underlying suspicion being investigated. Lawful orders remain lawful even if the original allegation is later unproven. This is where the concept of lawful detention becomes decisive. Prosecutors assess whether officers had reasonable grounds to detain individuals based on reported threats and corroborating information from mall personnel. The transcript reflects multiple references to reports, prior incidents, and requests for verification. That context matters legally. Detention authority does not require certainty. It requires articulable reasonableness at the time. If detention was lawful, refusal to comply becomes legally consequential. Resistance is defined by action, not belief. A subject's personal assessment of innocence is not a defense. Courts have repeatedly held that disputes over legality must be resolved later, not through non-compliance in the moment. This principle exists to prevent investigations from collapsing into individual vetoes. Another misconception fails here, that constitutional rights are violated by being touched or restrained during detention. The Fourth Amendment permits reasonable force to effect lawful detention or arrest. Whether force was reasonable is evaluated objectively, based on resistance, safety concerns, and control needs. Verbal disagreement does not limit officers' authority to use proportionate force to gain compliance. The Fifth Amendment is also often misunderstood at this stage. It protects against compelled testimonial self-incrimination. It does not prohibit officers from asking questions. It does not prohibit arrest. It does not prohibit charging. Its power lies in silence, not argument. Statements invoking amendments do not activate protections unless accompanied by actual exercise of the right, such as refusing to answer questions. This explains why certain defenses feel intuitive but fail in court. Claiming, "I didn't know I had to stop," rarely defeats resisting charges because the law does not require prior education. It requires compliance with lawful orders. Claiming "I was going to comply" does not negate resistance if conduct shows delay, pulling away, or refusal. Courts evaluate actions, not assurances. Prosecutors now examine the totality of the encounter. Bodycam footage, officer reports, witness statements, and audio all converge. Inconsistencies are not resolved in favor of the loudest voice. They are weighed against subjective recordings. This is why officers repeatedly emphasize commands and document refusals. Clear command-response sequences strengthen legal sufficiency. Aggravated assault allegations undergo particularly strict review. Prosecutors must establish that conduct went beyond passive resistance. Statements about being touched or restrained do not satisfy this element. The focus is on whether actions created a credible threat to officer safety. That determination is fact-specific and heavily dependent on articulation in reports rather than confrontation at the scene. This stage also clarifies why officers avoid engaging with threats of lawsuits. Civil remedies are separate from criminal processes. Threatening litigation has no effect on arrest authority or charging decisions. Courts treat such statements as irrelevant to probable cause. Officers remain calm because acknowledging or debating civil claims introduces risk without legal benefit. The mall context continues to matter legally. Public spaces elevate certain offenses because disruption affects more than the immediate parties. Disorderly conduct statutes often hinge on location. Behavior that might be tolerated in private becomes chargeable when it interferes with public safety operations in a crowded environment. Prosecutors consider that setting carefully. Another invisible legal principle emerges: cumulative exposure. Each charge carries its own penalties, but together they influence bail decisions, plea negotiations, and sentencing ranges. Even if some charges are later reduced or dismissed, their initial presence shapes the trajectory of the case. This is why early compliance has a disproportionate impact. Small decisions compound. At this point, the law is no longer asking who was right. It is asking what can be proven. Proof is built from compliance, commands, refusals, and force responses. Emotional narratives fade. Procedural records endure. This is the quiet power of documentation over debate. The legal question resolved here is why charges proceed even when subjects maintain innocence. The answer lies in evidentiary thresholds. Innocence is adjudicated at trial. Charging requires probable cause, not certainty. The system is designed to allow disagreement while preserving order. But resolving that question introduces the final and most consequential risk. Once charges are filed, control shifts entirely out of the subject's hands. Prosecutorial discretion, judicial rulings, and statutory interpretation now govern outcomes. Statements made earlier cannot be recalled. Actions cannot be reframed. The record is fixed. The closing takeaway is procedural, not moral. Lawful authority expands quietly during investigations. Speech remains protected, but conduct is regulated. Silence preserves options. Resistance multiplies exposure. Officers remain calm because the law rewards clarity, not conflict. Cases like this reveal patterns most people never notice. The decisive moments are rarely dramatic. They are procedural. They unfold through compliance, restraint, and documentation. Understanding those mechanics explains why outcomes often surprise those involved. If you were evaluating this case as a judge or juror, which element would weigh most heavily: the lawfulness of the detention, the clarity of commands, or the subject's response to them? Courts balance those same questions, guided not by instinct, but by statutes, precedent, and the constitutional limits that shape every step from first command to final charge.